To my family, friends, supporters, and colleagues, I want to speak to you directly and from the heart. This is a shakedown.
If you say that one more time, I'm going to choke out of you when I see you.
Busby and this young woman got audio, video, and text messages. If you know all of those things are out there, you should shut the F up. I'm not here to speak to Shannon's guilt or innocence because I don't know, but I do know attempting to settle looks like an admission of guilt because I'm not settling.
Breaking overnight, the sports world woke up to a fierce rebuttal from Hall of Fame tight end and media lightning rod Shannon Sharpe, who has now placed a high-stakes counter-narrative on the record. Less than 72 hours after court papers revealed insiders say the network often waits for legal milestones, dismissal, settlement, or trial verdict before exercising those rights. In Sharpe's case, viewership numbers have spiked 18% since news broke, complicating any calculus that ratings might dip.
ESPN is owned by Disney. So they pay big, but they expect big too.
On the financial front, analysts at Apex Sponsorship Group estimate Sharpe commands mid-six-figure integration deals per quarter across podcast and digital assets. A prolonged court battle could spook ad buyers who crave predictable brand alignment. Yet the anti-slap angle provides a narrative of proactive defense, potentially reassuring some partners. Apex co-founder Malik Jefferson summarized it this way.
It says Shannon Sharpe may have a beefy media deal on his hands, but he has much more pressing matters to attend to now. An anonymous woman accused him of a $50 million lawsuit.
His latest First Take segment topped morning ratings, and merchandise sales featuring the phrase "facts over fiction" reportedly jumped by double digits within 48 hours. Yet volatility lurks. A single leaked deposition excerpt could swing sentiment overnight. Media strategist Jordan Klein likens the scenario to a high volatility stock. Investors love upside, but sudden shocks trigger panics. Sharpe's brand sits on that knife's edge. In the coming weeks, journalists will parse every docket entry, influencers will stretch thumbnails to full caps hysteria, and legal Twitter will dissect each comma. Sharpe's next move will likely involve serving discovery requests, seeking phone logs, social media metadata, and potential third-party communications between the plaintiff and any media outlets. That tactic aims to unearth coordination supporting the anti-SLAPP claim. Conversely, expect the plaintiff's counsel to subpoena any internal memos suggesting Sharpe orchestrated a defamation counteroffensive. Settlement remains the wild card. Even after fiery denials, parties often calculate that controlled payouts beat protracted uncertainty. Yet both sides appear dug in. Sharpe's attorney told Sports Business Daily that our client will not reward defamatory behavior. The plaintiff's representative retorted that justice cannot be bought at clearance prices. Translation: each camp believes momentum favors them, and neither wants to blink first. Public relations experts warn that silence gaps can amplify rumors. Sharpe's decision to launch a weekly update show counters that risk, but it also raises expectations. Audiences will demand new information. Recycled talking points could breed fatigue. Maintaining narrative freshness without compromising legal positioning becomes a delicate juggling act, especially given discovery gag orders courts often impose to protect jury pools. One subplot involves the National Football League, where Sharpe spent 14 seasons. League policy bars current employees from commentary that might prejudice legal proceedings, but Sharpe's analyst role sits outside that jurisdiction. Nevertheless, NFL media properties monitor segments to avoid liability for guest statements. An executive with knowledge of network guidelines says producers now apply heightened review to any discussion of the lawsuit, ensuring on-air claims remain verifiable. Financial institutions, too, are watching. Sharpe recently inked a multi-year ambassador deal with a fintech startup targeting underserved communities. Industry insiders say the company inserted a morals clause that allows renegotiation only upon adverse adjudication, not mere allegation. This exemplifies a trend where partners seek objective legal milestones before acting, acknowledging that reflexive termination can spark backlash. As the legal chess match unfolds, Sharpe's legacy narrative is at stake. Retired athletes often pivot to media to extend relevance. Rare is the star who rebuilds stature after a credibility implosion. Sharpe's time-tested formula: brands tolerate controversy if the talent projects certainty and offers a plausible path to vindication. Notably absent from Sharpe's monologue was any direct reference to the plaintiff by name or to specific incidents. This omission is strategic. Nevada courts often view granular rebuttals as premature admissions. By restricting commentary to broad denials, Sharpe avoids locking into a factual timeline before discovery.
Says the Jane Doe alleged various instances of toward the end of 2024 and beginning of 2025. In addition, she claimed that she had a long-lasting and abusive relationship with the former athlete.
Fiery debate, southern wit, and unapologetic swagger faces its sternest test yet. Pass that test, and he cements a blueprint for crisis resilience in the influencer economy. Fail, and the fall could overshadow Hall of Fame rings. Reporters will track docket numbers, but fans care about human stakes. Does Sharpe's defense suggest malicious fabrication, or will evidence paint a different picture? Jurors, if seated, must weigh sworn testimony against social media narratives. Lawyers draft motions, but public opinion renders verdicts daily through clicks, shares, and podcast downloads. That parallel court of public sentiment often shapes opportunities long before a judge gavels opening statements. The first procedural skirmish lands next Monday, when Judge Rebecca Morales will hear preliminary scheduling arguments. Expect lawyers to debate discovery scope, deposition timing, and protective order language. Observers note that Morales has a track record of strict timelines, signaling she may fast-track the anti-SLAPP motion to clear calendar congestion. A ruling there could compress or prolong the controversy. The move mirrors guidance from veteran crisis management consultant Ella Briggs, who advises clients to deny clearly, litigate aggressively, and preserve factual bandwidth. Looking ahead, key dates loom. Sharpe's legal team has 20 days to file the formal anti-SLAPP motion. If granted, the burden shifts to the plaintiff to demonstrate probability of prevailing.
I have nothing to do with this. I haven't seen anything. I don't know anything. I don't even know this person.
A steep evidentiary bar requiring admissible proof, not merely allegations. Failure to meet that standard could result in dismissal and recovery of Sharpe's attorney fees. Conversely, if the court denies the motion, both sides march into depositions, document subpoenas, and expert witness duels, a marathon that can drag out for years. Parallel to courtroom maneuvering, Sharpe appears intent on controlling the media side to caller reactions, with one listener insisting if he's truly innocent, transparency will clear him. Another caller warned that powerful figures often use financial muscle to bury uncomfortable stories. The discourse underscores a broader cultural tension, balancing belief in alleged victims with the presumption of innocence for the accused. Sources tell this channel that ESPN retains morality provisions, allowing termination if talent materially damages brand reputation, potentially diluting or amplifying lawsuit updates depending on news lulls. Observers speculate that Sharpe's filing date, Monday morning, pre-draft frenzy, was chosen to seize a clean news window and dictate the narrative before another headline wave. All told, the coming months will test how effectively a modern media enterprise can navigate high-stakes litigation in the full glare of the influencer economy. Shannon Sharpe enters this arena with decades of competitive instincts, an army of digital followers, and a legal team versed in aggressive defense. The plaintiff brings serious allegations, counsel determined to prove validity, and a cultural moment that foregrounds accountability.